Good afternoon, ladies and gentlemen, and thank you for joining us this afternoon. We will just wait a couple more minutes. We've got some more people registering and signing in as we speak. Just a little bit of housekeeping. This topic of managing difficult employees always tends to generate a lot of questions. So we will have time at the end of the webinar and we will try to be responding to as many of those questions as possible. However, if we don't get a chance to get to yours, please bear with us. We will be calling everyone that's actually left a question at the end and having a chat to you to hopefully help you get on top of whatever the query is. But if you could please ensure that any question you'd like to raise is added into the Q&A function that's at the bottom of your screen and not the chat. Just a bit easier for us to manage in the Q&A session. So we do have a few more people logging on, but I think it's probably about time we can get underway. So firstly, a very, very warm welcome this afternoon, and thank you for giving up your time to join us here. Managing difficult employees is always one of our most well-attended webinars in our calendar of events, and I think it's for very good reason. And getting this wrong can very quickly lead to claims of discrimination, harassment, bullying, adverse action, or even unfair dismissals and general protections. And it can be very easy to slip up when managing a difficult employee, particularly if we let emotion or bias cloud our judgment as managers, or if we make snap decisions in the heat of the moment without following a formal or a well-documented and thought out process. Now, Australia's got one of the most complex ER landscapes of any country in the world, and it can at times seem as if the laws are skewed in favour of the employee to ensure their protection in the workplace. But the best way to avoid finding yourself in hot water is to set yourself up for success right at the beginning. Ensuring an employee has a clear understanding of what is expected of them is critical. This is addressed through the provision of well-drafted contracts, a robust set of company policies that have been read and acknowledged by the employee at the beginning of their employment, clear performance objectives and KPIs, frequent catch-ups with management, and an open, honest, and transparent feedback loop. In the vast majority of cases, we have found that issues stemming from poor performance that end up before the Fair Work Commission could have been avoided with the appropriate preventative measures and proactive management practices. And I think that's one thing that we as managers must recognise and remember. We are ultimately involved in the performance of the employees, and at the end of the day are ultimately responsible for their performance. No one enjoys entering into performance management discussions. It's unpleasant for the employees themselves, the managers who must oversee it, HR if they're getting involved, or other key decision makers within the business. But that's no reason to shirk responsibility or wait until an issue has gone nuclear before we take the necessary action. And that's what we're going to be looking at today in a little bit more detail with my colleague Carla. So without further ado, let's get into it. Your presenters today is myself, Alistair McDonald. I'm the Head of Business Development and Marketing for FCB Group, of which HR Assured's a part, and I've been with the business for a little over 8 years. And I'm also joined by our resident expert and workplace relations consultant, Carla Ahmed, who's going to be doing the bulk of the lifting today. So before we begin, just to give you an overview of the group and who we are, FCB Group comprises 5 lines of business. On the far left of your screen, you can see the oldest part of our business, 30 years old, FCB Workplace Law, which remains one of the leading specialist employment law firms in Australia, and our Smart Visa immigration law and migration practice as well. We've then got HR Assured, which is the brand under which we're coming with you today, and Enable HR, which is our in-house proprietary HRIS software. And most recently, we've welcomed QMS Certification Services, which joined the group in January and has rounded out our compliance offering through the provision of ISO certification services. So HR Assured, a summary of our service offerings up here on your screen now. It's essentially a outsourced HR solution that helps businesses take control of their people management. So it starts off with a comprehensive HR audit that's done on the business itself, 24/7 unlimited telephone advisory service, our HRIS software, a library of legal resources and templates, over 200 of them in fact, and insurance and representation from FCB Workplace Law. So if you do find yourself dealing with an issue, particularly one stemming from managing a difficult employee, FCB Workplace Law will actually come in and represent the business with no out-of-pocket expenses to yourselves. We also offer work health and safety management systems. Again, very similar in the provision of the service, audits, personalised advice, and our policies and procedures managed through the software. So if you do have any inquiries about HR Assured, or you're looking for an outsourced solution for your business, please reach out to us and we'll be very, very happy to talk you through them. So without further ado, I'll hand over to Carla, who's going to take us through what we're going to cover in today's session. Over to you, Carla.
Excellent. Thanks, Ali. So guys, I guess jumping straight into things today, we know that managing difficult employees can cause a headache. It can be a challenging area to navigate, especially when frustrations are often running high. Through our experience, managing difficult employees can be made significantly less stressful when you know you're equipped with the right tools, knowledge, and support to address the issue appropriately. And obviously, we want you to be able to ensure that you have continued success within your business. Today, we'll be taking a look at the underlying issues that might lead to poor performance, how to undertake performance management and a formal disciplinary process, what to do when performance does not improve despite your efforts, and what happens if you ignore performance or conduct issues. Finally, at the conclusion, we'll take the time to answer your questions. Obviously, we understand there's going to be quite a few questions today, or we hope there will be, so we'll get to as many as we can. So we often find that there can be confusion by some supervisors and managers about the difference between managing poor performance and taking disciplinary action. Performance management is a great tool to draw upon when employees are not meeting workplace expectations. So this might look like employees not producing the quality, quantity, or efficiency of work that you require from them. On the other hand, we have conduct issues, and these are often thought of in relation to a clear breach of company policies and procedures. So while the difference between poor performance and conduct issues might seem basic, in a complex workplace situation, they can actually be quite difficult to apply with clarity. Perfect. So we're going to touch on performance management to begin with. Starting off, many managers often focus on the results as a performance issue. So for example, within your business, if a sales target is to meet 100% of the target and the employee fails to do that, often the employer focuses on that poor result as the performance issue. What we suggest, however, is the result is a symptom of poor performance. So managers need to focus on what the underlying cause of poor performance is. So for example, what is leading to that result? What is the employee not doing right that is leading to this poor performance outcome? Today, we have some examples of what may be the underlying causes of poor performance. So from an employee's perspective, this might include a lack of knowledge or awareness of the business expectations. There may be issues involving the employee's workload, their personal capacity, or even personal motivation to complete their role. On the other hand, from a business perspective, the root cause of poor performance may be due to unrealistic expectations that are set for employees, insufficient training, or even potentially a lack of leadership and direction for employees to follow. So by no means are these issues extensive, but we have found that these can be relatively common when we're looking at what might have caused the performance concern. This area definitely isn't a cookie cutter kind of area. It can be very different depending on your business circumstances. So it can be a really good time to be able to have a chat with a HR consultant to kind of nut out exactly what your issues are and where they might be coming from. So taking the initiative to dig deeper and think about what might be causing the underlying issue will assist in navigating the problem and obviously managing the employee most efficiently. Perfect. So when you engage in performance management, the most common end goals can include improving performance outcomes, identifying areas that training and development are required within, positively re-engaging employees and improving their behaviour. Engaging in this process will also allow you to identify what exactly is preventing your employees from performing up to scratch, and it provides a really good opportunity for you to be able to facilitate good employee relations. Okay, so you're in the position of understanding that performance management is going to be the best course of action for you and your employee. You can identify the underlying causes. You know that engaging in this process is going to lead to positive outcomes for your business and the individual employee, but where to now? When undertaking performance counselling processes, it's important to have a plan. So this involves identifying the performance concerns, what's causing them, and what's the desired outcome. As you can see, we've stepped this out for you on a flow chart, which you'll be able to see. So just reiterating, where we start by pinpointing the root cause. We then dig a little bit deeper and identify how the poor performance might be categorized. Here, I would encourage you to ask yourself whether the poor performance is capability, capacity, or behavior related. Next, we consider if there are any other factors contributing to the poor performance. And finally, we consider what type of outcome you might like to achieve as the employer. So are you aiming for performance improvement? Are you looking for employee compliance? Or is termination potentially on the cards here? Engaging the employee in a performance counselling session can be an incredible tool to address behavioural concerns, work alongside the employee to help them improve or learn, and it also gives the employee the opportunity to discuss their reasoning, provide additional context, and may raise any barriers that might be impacting their performance. So when meeting with the employee in a performance counselling session, a great tool is to have prompts that you know that you can draw upon to elicit insightful answers and therefore gather a better understanding of their problem. So really good prompts that we often recommend to our clients include, why did you? Or from your perspective, what happened? Another really good one is, what prevented you from? So these open-ended style questions allow the employee space and time to be able to elaborate on their views. This ultimately helps you as the employer paint a clear picture of how and why their performance is suffering. The performance counselling process can also help identify whether the employee was solely or partly responsible for the issue at hand, whether they were at fault, and was the business's performance expectations realistic. After speaking with the employee in a performance counselling session, it can be beneficial to reflect and consider the following. So did the employee have knowledge or awareness of the issue? Did the employee have a claim? Did the employee have or claim the skills and experience required to do the task? All right, so we've all heard of them, but many organisations actually fail to utilise them properly. So performance improvement plans, or PIPs, as you can see on the slide, should be used when there is a commitment to help the employee improve, not merely as a way to look at terminating an employee. So for example, it's often the case that managers implement a PIP for an employee who continually breaches processes and protocols, and the company potentially wants to terminate. This might not be appropriate in your particular circumstances. Where the company is genuinely looking to help the employee improve, PIPs can be an incredibly useful tool to draw upon. I would always recommend considering a few key points before going ahead with implementing a PIP. So let's think about, is there an actual performance issue that can be substantiated? So management should be able to list the deficiencies, including dates, specific data, and any previous reviews that you might have engaged in with the employee. Is the employee's manager committed to assisting the employee? And is there a known personal issue that may be affecting the employee's performance? So as we can see, there's quite a comprehensive lot of issues that we need to look into before we actually jump into implementing a PIP. Again, navigating this on your own, as we understand, can be a little bit tricky. So sometimes being able to chat to someone else, air what you're thinking, let us know what information you've gathered from the employee so far can be a really great opportunity for you to make sure you're heading in the right direction. Okay, so to formalize a PIP, it sounds like a great solution, but what should you actually put in this plan? I like to recommend to clients that they set out a detailed document that should include information on what the acceptable performance levels are and specific examples of when the employee's performance has been deficient. So again, like we just discussed, that's talking about dates, specific occurrences that have happened, and just really being as detailed as you can so that the employee has a clear understanding of where they're not meeting your benchmarks. Note down some specific and measurable objectives that are achievable, relevant to the employee, and should be achieved by a set time frame. So performance improvement plans might last for 30, 60, or even 90 days. Setting the time frame is really dependent on how long it will take the employee to make meaningful improvements to address the specific issue. Again, like we've sort of already touched on, this isn't necessarily a cookie cutter approach. It's very specific to your business. And again, being able to consult with someone and figure out what's right for you is a really great thing to be able to do. So the improvement plan should set out what your business's management team will do to support the employee in improving. This might look like providing the employee with extra training or coaching or even a mentor. I also recommend noting down how often the manager and employee will check in to discuss progress. This might be once per week, or it can vary depending on your specific circumstances. Finally, noting down the consequences for not meeting the objective of the PIP is a really important thing to include. We want to be as specific as possible to the employee. So this might look like highlighting that the employee will be issued with a warning letter should their poor performance continue, or potentially even termination in more serious circumstances.
Thanks, Carla. Now, ladies and gentlemen, we thought we'd just pause here for a moment. As we've said before, the sphere of performance management can throw up a raft of questions. And if you'd like to speak to Carla or one of her colleagues, please get your mobile phone out and point it at the QR code now. And we will, in fact, give you a time to actually have a chat to one of our consultants, completely complimentary, obligation-free, to work through perhaps some of the issues that you're currently dealing with now in regards to managing difficult employees. So please do take the time. If you'd like to book some time with us, we'd be very, very happy to have a chat to you.
Excellent. So we've obviously now touched on the performance management side of things. Let's now go ahead and look at the disciplinary process. So we've obviously taken quite an in-depth look at performance counselling and PIPs, but what exactly is the disciplinary process on the other hand? So a disciplinary process is generally used where the employee has engaged in misconduct. So misconduct can range from lesser to more serious issues, and determining how to categorise behaviour is dependent on your particular circumstances. So for your understanding, serious misconduct is categorised as behaviour that is sufficiently serious to cause damage to the business or other employees, and it might typically involve a breach of policies and procedures. Determining whether the type of behaviour that you're dealing with is considered serious misconduct can be a great question to reach out to our advisory team for. Often when understanding the disciplinary process, the outcome will be a warning of some description, but in more serious circumstances, it might actually lead to termination. So in a business setting, if you feel as though a conduct concern has arisen, it's important to determine a number of different factors. So what is the nature of the conduct? Does the matter require you as the employer to undertake an investigation? So circumstances that might give rise to a further investigation could include whether conduct concerns suspected fraud, allegations of assault or theft from the business. You might strongly consider engaging the employee in a disciplinary process. To ensure that you engage in a disciplinary meeting in a procedurally fair manner, it's incredibly important to make sure that you provide the employee with at least 24 hours notice of the meeting and obviously notify them that they're able to bring a support person if they wish to do so. We recommend conducting the meeting and considering the employee's responses. It's important to go into this process with a willingness to listen to the employee, and obviously gathering as much information as possible is imperative to a thorough and effective disciplinary regime. Finally, as the employer, we recommend you decide on an outcome and follow this up in writing so that the employee is firmly aware of the business's stance. Alrighty, so what if performance doesn't improve? Where does that leave you as the employer? If you've put in time, effort, and support into the employee following performance or disciplinary issues, and you're still not seeing the sufficient level of improvement, you will need to consider your options. I recommend considering if the performance plan should maybe continue. So if some goals and objectives of the PIP have been met, but you're still looking for that additional level of improvement, potentially reviewing and renewing the time frame set for the PIP can be a really good option. Maybe approach the issue from an engagement perspective. So is the employee happy in their role? Are they struggling with their current role and what it requires of them? And would they maybe be better suited to an alternative position that the business may have available? Again, when it comes to performance management, it's not always that cookie cutter approach. We're not always going to go down the route of a warning letter or a termination. Sometimes that might mean addressing the issue from a completely different angle. And like we've suggested here, sometimes looking at engagement can be a really good way to do that and actually get employees back on track and obviously have your business performing in the most efficient way possible. Finally, do you need to consider a termination? So obviously when assessing whether the employee should or even can be terminated, it's incredibly important to ensure that the dismissal is not unfair, unjust, or unreasonable. If you get to the point of considering termination, it can be a really crucial time to engage with a HR consultant. Consider the circumstances at hand, prepare written reasons that reflect why the performance may result in termination, and reflect on the tools that the employee has been provided with to assist in their improvement. So this is where Ali said earlier that engaging in a really well-documented approach is imperative. Obviously at HR Assured, we have really good tools and templates for you to be able to draw upon to make sure that you're going through that process in the correct way. Along with those tools, we've obviously got our advisory service, which again is really good to be able to console in another person to be able to let them know where you're at. So what happens if you get performance management or the disciplinary process wrong? Obviously, having performance discussions or conducting a disciplinary meeting can be challenging and uncomfortable, especially if you feel as though you are walking in the dark and you don't know how to handle this kind of situation. It's not something you've done before. You know that it's a risky area. You want to make sure that you're going in feeling confident and like you have the tools that you need to be able to handle this properly. Engaging in either a disciplinary or a performance management process can be a really fine balancing act for HR practitioners and even for managers if they're involved within that. A balancing act is really necessary to ensure that the business is protected and to potentially protect management persons if they're involved within this procedure. It's really important that the business remains impartial and ensures fairness to all parties involved in the situation. So yes, we want really positive outcomes, but we want to make sure that the way that we're going about it isn't negatively targeting anyone. And we just really want to make sure that we are creating a really fair space for everyone to be able to improve and obviously also address the issues within. We also want to ensure that any relevant law is being observed so that you're not placing yourself in any kind of personal risk. So we understand this is not easy and never ideal where a management representative is accused of acting to facilitate a specified desired outcome. We want to make sure that when you go into the disciplinary process or when you go into a performance management type of meeting, that it comes across as it's being fair and just and no kind of prejudice is being had against the employee. Reasonable management action undertaken in a reasonable manner should not increase an employer's risk profile. However, if the process is not undertaken correctly, it can lead to a range of claims as listed on this slide. So let's take a look at those potential areas of risk that you might run into if you don't get this process right. So firstly, an unfair dismissal is the first claim that might arise if the performance management or disciplinary process is not done correctly. This claim may rise where there are procedural deficiencies. So this might look like, from the employer's perspective, failing to give the employee an opportunity to respond to any reasons for dismissal related to the capacity or conduct of the person. It might also look like an unreasonable refusal by the employer to allow the employee to have a support person there beside them to assist in any discussions relating to the dismissal. It also might look like failing to warn the employee about their unsatisfactory performance before the dismissal. And it can also include flawed investigations. So the next claim risk that might arise is a general protections claim. When engaging in any kind of performance management, it is incredibly important not to take adverse action against another person because of a protected attribute. So if an employer were to take adverse action against an employee, this might look like dismissing the employee. It might involve injuring the employee either mentally or physically during the course of their employment, and it might also include discriminating against the employee and other employees within the business. So yet another risk that might arise could include a discrimination risk. Sometimes when an employer might be engaging in a performance management process, you may uncover more to the situation than you'd originally thought. This might include the employee having a disability of some kind or any other protected attribute that has led to the poor performance outcome. So here on the slide, we've got some really good examples. So a manager commences a performance counselling process and asks the employee why they haven't been meeting targets. And the employee's response is they're finding it hard to concentrate at work due to mental health issues. At this point, the employer needs to ensure that it gathers information regarding the issue before proceeding, or you risk a discrimination or general protections claim in this kind of scenario. Another really good example is if you were to involve an employee in a disciplinary process for behaving aggressively and they divulge that they're experiencing a psychotic episode at the time. Further information needs to be sought to avoid disciplining an employee for actions which might be attributed to a mental illness. In these types of situations, the employer might have to engage in a capability review process. This can be, again, an incredibly delicate area to navigate. So we always recommend getting detailed advice specific to your circumstances in this type of scenario. We obviously want to make sure that you don't run into risk and the actions that you're taking are as risk adverse as possible. So I guess these are some really good examples just to bear in mind if you have a situation that might be similar. In some circumstances, a workers' compensation claim may be raised by the employee. So this would constitute where the employee claims that the performance management process has caused them psychological injury or stress. For this to kind of eventuate, the psychological injury needs to have been caused or aggravated by work for the employee to be eligible to make a workers' compensation stress claim. However, it can be easier to make the argument if the employer has not followed due process or has been too harsh in their approach. So again, referring back to taking that really well documented, detailed approach to performance management or disciplinary actions, this is why it really is important. I should flag as well that each state also has different workers' compensation legislation. So this can be tricky to navigate and understand when it's not necessarily your area of expertise. And it's usually an area that we do encourage you to reach out for support for to ensure you have a comprehensive understanding of the risks and issues for your particular circumstances. So the final risk that I guess we're going to touch on today will be bullying and harassment claims. So in our experience, we've seen many employees claiming bullying and harassment when their employer engages in a formal process to address performance. Determining whether management action is reasonable and requires an objective assessment of the action in the context of the circumstances and knowledge of those involved at time. So we have to think about things including whether the circumstances that led to and created the need for the management to take action. We also have to think about why did management take action and the consequences that flowed from the management action. Generally speaking, management actions don't need to be perfect or ideal to be considered reasonable. A course of action might still be reasonable if the particular steps are not followed. So obviously we do have a really detailed kind of process that we recommend following when going through any kind of disciplinary or performance management processes. We're not necessarily saying you have to follow them perfectly to a T, but it's all about knowing how to follow the process so that you know where you can, I guess, differ and where you might have leeway. So we need to make sure as well that any unreasonableness must not arise from the actual management positions taken. Perfect. So I guess as we reach the end today, we're going to look to leave you with some tips and tricks so that you know that you're going forward with performance management and disciplinary actions in confidence. So obviously, when you're going through the performance management or disciplinary process, as we've touched on, formal documentation is crucial. Keeping really detailed accounts of the actions of the employee, any actions that you've taken, and any responses from the employee is imperative and particularly important if a claim is ever to arise, so that you do have that detailed kind of documentation of any approach that's been taken. It's important that you have detailed evidence of the lawful, objective reasons for actions to substantiate the business's actions. So again, this ties back to the first point. We want to make sure that we have a really clear evidence of where the employee's gone wrong and why we're taking these actions. You want to make sure that going forward with any kind of disciplinary or performance management protocol, that you have an uncompromised, impartial decision maker. So like I said earlier, I totally respect that this area can be very emotional, it can be frustrating. So being able to debrief with someone and console with someone and let them know how you're feeling, what's going on, and then bring you back down to earth to make sure that you go forward with a level head and handle this as best you can is a really great thing to be able to do. We encourage that you update your contracts to include express provisions around misconduct. So this might look like obviously clauses within your contract. It might also mean a really detailed set of policies and procedures to sufficiently cover you so that employees understand where they'll be left if they don't meet your expectations. And then, of course, we advise that you seek advice from a HR advisor before making any firm decisions. It's really important to be measured and not to rush into this kind of process, obviously, because there are quite a few risks that are involved. Another really good tip, we haven't got it here on the slide, but something I often like to stress to clients is that often trying to approach disciplinary and also performance concerns from a positive angle can actually lead to really good outcomes. So some really good prompts to use might be, we've noticed X issues and we want to work with you to facilitate improvement in these particular areas. We're able to support your improvement through doing this. Is there anything in addition that you think that the business could do to support you in these changes? Are there any barriers preventing you from improving in these areas? And would you like to discuss them further? So avoid absolutes, such as the fact of the matter is. It shows you're not willing to consider other views. So again, we want to go in with that open mind, that level head, to make sure that we're handling everything as procedurally fair as we can. We obviously want to invite healthy dialogue and understand the best options by gathering all information possible. If you go into any of these procedures with an open mind and you're looking to communicate calmly and clearly with the employee, we often find that your success rate is actually a lot higher than if you go in emotionally charged and not ready to kind of listen to the employee, hear all sides of the story and take a really fair approach to it.
Carla, thanks so much. Ladies and gentlemen, today I just wanted to put this out there as an offer to everyone that's currently on the webinar. I think we said right at the beginning that one of the best ways that you can optimize your business and protect it and ensure that it's set up correctly to get the most out of your employees is really to get on the front foot and to have the right architecture, framework, documentation, particularly in regards to policies, and to ensure that the business is set up correctly. So for today, normally valued at $750, we'd like to offer our free HR health check to everyone that's on the call. Again, very similar to the telephone advisory service. We'll just give you a moment to take out your phone and click on the QR code. It takes about 30 to 35 minutes normally from your end, but there's no preparation required from your end at all. It's just a one-on-one with one of our consultants who'll walk you through some questions and then provide you with a very short report, traffic lights, green, red, and yellow, just to give you a good idea of a baseline of how your business currently sits, both from a compliance viewpoint, but as well as best practice. Now, while everyone's clicking on that, I'd just like to turn our mind to the questions and answers. We have had quite a number of questions here, so we will, let me find a couple here. So one of the first ones, Carla, if I can put these to you, if I may. The first one, can't I just fire them? They're annoying me and PIPs are difficult and capacity reviews take a long time and I just want them gone.
Yeah, really good question. So I guess my biggest piece of advice would be that it is incredibly important not to just fire them, because we've touched on, there's lots of risk involved. So we've got unfair dismissal risks, we've got general protections claims, we've got discrimination claims, and the list goes on. We acknowledge that the process of a PIP can be daunting and draining. So having a HR consultant to debrief with, seek tailored advice, and map out the next steps is an incredibly useful asset to you. If the business is ever in a position to terminate, it's important that there is evidence to support that the business has taken a measured approach towards lending a helping hand to the employee. We obviously want to flag that there are issues that require improvement, attention, and then providing the employee with a reasonable period to make meaningful change is another really important thing to consider. This is why we recommend taking a really comprehensive approach when dealing with difficult employees instead of just rushing into it and firing, even though that can be often what we want to do as employers.
Yeah, the rush to the bottom. Indeed. Thanks, Carla. The next one, how many warnings do I need to give a difficult employee before I can fire them?
Again, another really, really good question. So I guess contrary to common belief, there isn't actually a set number of warnings that you need to give an employee before you can look at a termination. It's important to take into account whether you have a carefully documented evidence of improvements or step backs in the employee's behaviour or performance after engaging in a formal meeting or disciplinary process with them. Deciding when you might be able to terminate is very dependent on the type of nature, severity, and duration of the conduct. It's great to be able to speak with a consultant to talk about your particular circumstances. Again, like I've really tried to emphasize, managing difficult employees unfortunately isn't a cookie cutter thing. It's very dependent on your particular situations. So yeah, just to reiterate, no set number of warning letters. It's very important to look back at the history and be able to see what steps you've taken as an employer, and also what kind of improvements or step backs we've had from the employee.
So Carla, just expanding on that, I mean, the 3 strikes you're out policy seems to be the most prevalent in today's business world. Is that, in your experience, you sort of see as being the one mostly adopted by businesses? Is that, 1 warning letter, 2 warning letters, then you're out?
Yeah, I would definitely agree, but we often see that the people that are maybe successful in doing that is where they've got evidence of taking a really well documented approach with the employee to be able to substantiate why they're taking that 3-strike approach. It's not just a matter of being able to give an employee a piece of paper and say you've done the wrong thing. It's really the back end work that's really important in doing that.
Awesome. Thanks, mate. Next question. Can I stand an employee down before a performance counselling session or a disciplinary meeting?
Yeah, so you might have the ability to stand down an employee if you feel as though they are unsafe or could potentially cause harm to the business and its employees. We recommend reaching out to seek clarity again around your particular situation to see if this might be appropriate. In terms of performance concerns specifically, standing down someone might not be the best option for your business. This is why we recommend acting promptly and addressing performance concerns sooner rather than later to ensure business efficiency.
Okay. Mate, the next one, do I have to make a decision on the spot / during the meeting? I assume this is in relation to a counselling for poor performance type meeting. Do we have to make a decision? Probably not, I imagine, but over to you to answer.
Yeah, so look, as we sort of touched on earlier, eventually it's great to be able to make a decision and to be able to give the employee, for example, a written letter that kind of confirms what the decision is. But it actually is really important not to go into the meeting with a predetermined decision. So that's before where we were emphasizing that it's really good to be able to go in with a level head and open mind so that it is clear that you haven't come to a predetermined conclusion. Totally respect that can be hard to do when emotions and frustrations are running high, but it's best to take a step back and potentially conclude the meeting or take a short break. Maybe give someone a call if you have a HR consultant available, have a chat to them, just so that you can ensure you're proceeding in the most fair way possible. Often actually issues can arise if you head straight into the meeting with that predetermined decision. So stepping back can be a great thing to do to make sure that you're proceeding with confidence and knowing that you're taking the most procedurally fair steps possible.
Yeah. And I think the timing of the meeting can be quite important too, isn't it? Quite often, the blood can be up. You've found an issue, like get someone in the room within the hour. I mean, always sleeping on it, taking the time to actually pull together the information, to have an informed conversation, to probably let the red mist die down a little bit as well.
That's right. Yeah.
We've been through best practice. Mate, we'll come to another one if we could. What can the employee support person actually do during a disciplinary meeting?
Yeah, so a support person's role should really be to support. So it's not necessarily to act or speak on the employee's behalf. So this might look like a support person explaining things to the employee if they're having trouble understanding, or just providing moral support. So just having someone there they know that is on their side, I guess, and that they can lean on should they need support in this process. Sometimes stipulating that the role of the support person is truly to support and not to replace the presence of the employee in the meeting can be really good to outline an invitation letter. Again, through the HRA Cloud, which is part of our product, we obviously have letter templates and we obviously have the ability for our team to be able to review letters and things like that for you. So making sure that you include all these little details where you might skip over them, but actually they're really important. So for example, what can your support person actually do in your meeting can be really good to give the employee before going into that formal process. Having experience in assisting clients with these sort of matters on a regular basis has meant that our team has an eye for these sort of things, and we can understand where maybe you might run into these sort of issues, and maybe we can recommend that potentially tweaking one of the templates that we have and maybe popping in a sentence about what a support person can actually do could be a really good step for your business.
Carla, thanks so much. We've looked at the rest of the questions. I think a lot of them probably lend themselves a bit more to a one-on-one conversation. So for those of you, we've obviously got your contact details through the registration, and we'll ask someone from the TAS team to reach out and have a quick 10 to 15 minute chat with yourselves. So ladies and gentlemen, I'd like to thank everyone for their attendance today. I particularly like to thank my friend Carla and also everyone in marketing who's obviously helped in pulling together today's presentation. So we wish you all a great day and look forward to having you join us at the next webinar. Thanks so much.